webinar on legal issues and COVID-19. My name is Annalisa, and I work at University of Minnesota Extension along with Natalie Hoidel and Annie Claude, my colleagues. Just to know that we will be recording this today. There's a lot going on in the news with the shooting of Dante Wright and other issues. So if you aren't able to join us today, we hope that you will be able to watch the recording later. So just a little bit of context. We did a series of 3 focus groups last winter over the December and January of 2020 and 2021. And through those discussions with fruit and vegetable farmers, the issues around employment law and what people can require of their workers when they perhaps aren't on the clock came up quite a bit, and there was a lot of discussions, really good discussions about that. And that was definitely an area where we felt out of our depth and able to answer those questions accurately. And so we thought that having a webinar with Rachel would be an excellent way to answer some of those questions. So we hope that you, while you're listening today, have your questions ready. Feel free to put them in the chat and we will relay them to Rachel either during the webinar or perhaps afterwards. We will definitely allow time for question and answer afterwards. So with that, I will introduce Rachel. So Rachel Armstrong is the founder and executive director of Farm Commons, an organization that provides legal support, resources, podcasts, and other information for farmers and ranchers and their service providers. She lives in northern Minnesota with her husband and their 3 children. And Rachel is an invaluable resource for all of us as farmers that many of you know. So thank you, Rachel, and please take it away.
All right. Hi, everybody. Thanks for being here today. This is such an important topic to address and just to expose yourself to employment law and how it works and how it affects the farm overall. It's not always the most fun thing to do, so you get to give yourself a pat on the back that you are doing that anyways. You are showing up to learn about these topics that can be kind of nerve-wracking and kind of make your stomach feel a little queasy. It's not easy, and it's great that you are here and ready to take in some of these issues. You can also be a voice in your community afterwards about how employment law works. There's not a lot of people that really understand how employment law affects the farm, so it's super powerful that you can do that. So here we go. I'm going to go ahead and show my screen, adjust this a little bit. Farm Commons, you can find us on the social stuffs. And here's our presentation in employment law during COVID and beyond. So we are talking specifically about COVID and some of the impacts that it has on how you manage your employees. But a lot of the principles that we'll be talking about today are totally relevant beyond just the time of COVID. COVID is why we're talking about it, but there's still important principles and concepts to keep in mind no matter what. A little bit more about myself. I'm Rachel Armstrong. I grew up here in northern Minnesota, not far from where I live today. My background has always been in food and agriculture. Those are my ancestors way back, farming after, cutover area outside of Twig, if you're familiar with the unincorporated area of Twig. When I went to college, still everything I did was revolving around food and agriculture. After that, I worked for nonprofits. I worked on farms. But everything I did, I looked around and thought, we don't really have access to the kind of legal education that we need as producers and as agricultural community members. And I thought there must be a way to solve that. So I decided to go to law school and figure out how I could create Farm Commons. And it was an amazing stroke of luck. Turned out that way, and I've managed to get the organization off the ground as of 8 years ago. I'm still the executive director today. Our mission is to empower farmers to understand and solve their business law issues within an ecosystem of support. We really focus on education and networking and community dialogue and community consensus. Those are very powerful elements of farm business law. When we think of legal stuff, we usually think about courtrooms, litigation, understanding the rules, and those are all still very relevant, but there's so much that we can do with education, and we actually have a lot of power to influence farm business law overall in terms of the contracts we write, the negotiations that we have with others. And inside that ecosystem of support, certainly we include attorneys, and they play a very important role in helping us understand and solve business law issues. But it's also extension agents, it's nonprofit professionals. Each of us has a role to play in helping farmers develop resilience through education, through discussion. We're a 501c3 nonprofit. Workshops are a lot of what we do. They used to be in person, and then we canceled them all because of COVID. And so now you can take our workshops online. We also produce a lot of guides. We have a podcast. We run regular webinars. We also have a moderated and private social media platform for our members to discuss their farm law questions and what they're doing. And then we provide technical support to farm educators and organizations. So what I want you to know is that farm law education can reduce risk. That's why you're here, right? You want to reduce your risk. But it can also build stronger communities and can even create joy. Now, I know that's a bold statement. How can farm law education create joy? But it can. It can help you understand what you're doing right and where you can reduce even more risk, where you can sleep even better at night. When you know where your risks are, you're empowered to make the decisions that work for you. And what that can translate into is a better quality of life and a better focus on the reason you got into farming in the first place. And that, of course, translates into joy over time. So even though some of the emotions you might feel during this presentation are worry and concern and anxiety, we're on a path. We'll get to a better place. But the bummer part is that people say that you're not motivated by hearing about the great places you could go and the joy you could experience. They say you're motivated by pain. Research says you are more likely to act, you're more likely to change your behavior if I scare you, if I convince you that horrible things will happen if you don't take, my risk management strategy, that you're more likely to act. So, I would be derelict in my duties if I didn't also scare you. So that's how we'll structure today's presentation. I'm going to tell you about situations, and I'm going to try to spell situation correctly. I'm going to tell you about some bad situations and what you can do to make sure they don't happen to you. So bad situation number one. Let's say that you make vaccines mandatory to work on your farm. You require all of your employees, maybe even your volunteers or your interns, to work on your farm, and an employee gets mad. And that employee says, this is not allowed, and I'm going to sue you if you don't continue to retain me, even though I am not getting a vaccine. Uh-oh. Now, nobody wants that to happen to them. But what's the rules? What's the situation? Is that going to happen? Is that a risk? Well, here's the facts. Are you legally allowed to require vaccination as a condition of continued employment or as a condition of future employment for people that you will hire in the future? The short answer is yes. Yes, you are allowed to do that. You are within your rights to say the people on my farm must be vaccinated. But, ... Of course, there's a but, and we are going to talk about that too. There are two exemptions that you must offer. You must offer an exemption for religious beliefs and for disability or medical conditions. Now, the reason you have to offer these exceptions is because if you don't, what you're achieving in the end is discrimination. If you were to say that everybody must have a vaccine, and there is a certain group of people who, by virtue of their religious beliefs, will not be vaccinated, what would happen in effect is that you will never hire a person of that religious belief. And so even if you're not setting out to discriminate against a person of that religious belief, that effect is what is manifest, and that's against the law. So you must accommodate folks who have a religious reason for not getting a vaccine. It's the same with disability and medical conditions. If there's someone out there who just can't get a vaccine because of a medical condition that they have, then you would be achieving discrimination against them. if you would never hire them because of that. So the source of these comes from some very familiar laws. For religious beliefs, we're talking about federal anti-discrimination law, the Civil Rights Act of 1964. And what it says is that once an employer, what it says specific to the flu shot, to the flu vaccine, is once an employer receives notice that an employee's sincerely held religious belief, practice, or observance prevents them from taking the vaccine, then the employer must provide a reasonable accommodation. And in the words of the law, a reasonable accommodation is how they handle what you do for a person who has a religious belief. And basically, you just don't require them to get a vaccine. You can continue to require everybody else, but you have to offer them an exception. For the medical conditions, we're going to the Americans with Disabilities Act. And that's the source that says that, we can't discriminate against persons with disabilities. So there's more details behind this. You might be saying, well, what kind of religious beliefs? Do they have to be a part of some organized religion? What if they invented this religion yesterday? What if this is like your internet, marriage pastor kind of thing, where you can go get the authority of the internet, to perform marriages? What kinds of medical conditions? Is it just like, well, I don't want a side effect? Is that a medical condition? The bottom line is, if you want to explore, if you want to go down the rabbit hole, it is highly advised that you work with an attorney to do that. And that's because you are scooting more heavily into the realm of risk here. The Americans with Disabilities Act does define what are qualifying disabilities. But you don't want to go down that path unguided and start saying, well, what kind of disability? Because even your inquiry into the nature of an individual's disability, you can do that wrong. They're entitled to privacy around their medical conditions, and you do not want to create a situation where you're violating that privacy. You're not entitled to their medical information. So yes, there's a way that you can ask for documentation of the circumstances of their need for an exception, but do it with an attorney so that you don't make mistakes in terms of how you're doing that. And then all of a sudden you're exposed to more lawsuits, for asking for medical information that you're not entitled to. You could be creating hostile work environments because you're telling someone that their religion doesn't really exist. Like, we don't really want to go down there. So if you got to do it, talk with an attorney and they will guide you through it. So you can have these exceptions. It's a little tricky to do. Of course, the other way to resolve the risk that somebody is going to sue you for making a vaccine mandatory is to make it optional, of course. We've been hearing about this in the news. You might consider focusing on giving your employees support and incentives to become vaccinated. Or is that the word? Vaccinated. Maybe what they need is time off to make or to attend those vaccination appointments. Is childcare their concern? I heard around here that I wasn't supposed to I have 3 children. I have 3-year-old twins and a 5-year-old. I can't leave them at home. And I thought, oh my goodness, if I can't take my children to the vaccine location, that introduces problems for me. So is that where your employees are coming from? Can you help with that? Do they need educational materials about whether the vaccine is safe or appropriate or available? So see what you can do to add incentives in that help your employees choose to get the vaccine. And then you're not backed into a position where you're thinking about making it mandatory. Maybe you're also thinking that you want to restrict off-farm activities. What about saying, well, look, folks, I don't want to see you on Facebook attending a birthday party with 8 other people in the room. And if you do, I'm not going to let you come to work for a week. Or no out-of-state travel. If you travel out of state, you have to stay home without pay for a week. Can you do that? Okay, sometimes yes, you can do those things. But This is dicey. This is not something that you want to do willy-nilly or without being extremely diligent about how these things are done. Your best advice, of course, is to work with an attorney if you are trying to create off work time personal life restrictions for your employees. The number one thing you must do is be consistent. If it's a rule for one person, it is a rule for everyone. If one person can't go out of state, no one can go out of state. No, one person can't go to a birthday party, no birthday parties for anybody. The rules need to be extremely clear so that you can make sure you know whether we have a violation or whether we don't, so that you can be certain that you are always enforcing it consistently. Now, the more challenging one is that this does have to be relevant to the job and to the goal that you're trying to achieve. So, we would have to inquire, what is this person doing? If they're doing marketing for the farm and they work from home, it's a lot less of your concern if they get COVID. Sure, you don't want them to. Maybe they're going to be out of work for a day, a week, a month, but they might be out of work for a day, a week, a month for anything else too. They're not going to take COVID back to the farm and infect all your other workforce if they're a work from home employee. So that's your ability to restrict someone's off work time in that situation is going to be a lot more limited. You need to have a really good reason for doing that. Like, okay, you work closely with other people and I can't structure social distancing in this position in which you work. So there is a real risk that if you get COVID, you'll get everyone else sick. And if you do, I don't have any backups and I can't hire anyone else. And so you know where I'm headed. You have to have a really good reason for doing this. It has to be directly related to the work that they're doing and the job. And be careful. If you're doing this, work with an attorney, because what you think is reasonable and directly related to the job may not be what the law thinks is reasonable and directly related to the job. And it's very fact specific. So this is not necessarily a good, there's not like a guide you're going to find on the internet to really help you parse this out, because it's very specific to the conditions of work and the needs. Most employers are not choosing to try to restrict off work activities. There was definitely some thought and activity about that in the earlier days of COVID, but especially now with the vaccines and other management strategies that we have and the greater acceptance of distance working, socially distanced stuff, it's not something that people are tending to do. When people tend not to do it, it's going to be a lot harder for you to be able to do it. The law looks to, consensus and generally recommended practices. So an uphill battle. Okay, bad situation number 2. Let's say in this instance, an employee comes to work tomorrow and they ask for paid time off. Well, let's say they don't come to work tomorrow and they ask for paid time off for COVID related leave, and they tell you that this is required by law. What might be happening is that they're thinking about 2020. In 2020, we had a mandatory paid leave. This was the law. It was a federal law, so it applied to everybody, every state. And it mandated paid leave for illness from COVID, caring for a family member with COVID, while awaiting COVID test results after experiencing symptoms, and while caring for children who were out of care due to COVID at a school or their regular care provider. Now that obligation expired on December 31. So if this bad situation happens to you, you can say, oh, I'm sorry, but I actually don't have to give you paid time off because that law expired and we don't have paid time off here at this business. And hopefully they already know that paid time off is not available to them if it is not. So that law expired. It was called the CARES Act. You might have heard about it. But you should know that if you were required to offer it last year and you did not because you didn't know that, a lawsuit can still be brought against you. So in 2021, you can still get sued for time off that you denied in 2020. And that can still happen for 2 years from the time of violation, or maybe 3 if it was particularly egregious. So if we change our bad situation to employee calls you tomorrow and said, that leave you denied me back in September when I was awaiting a COVID test, well, that was not legal and now I'm suing you, then that's a problem. That can go forward. Also note that businesses were able to take a tax credit for paid sick leave that they offered. So even if you chose to provide paid sick leave in February 2021, you were able to get a tax break for that. The government would basically give you a credit on your payroll taxes for the costs of that paid sick leave. Now that expired, a couple weeks ago now. So, but there might still be time for you to take a tax credit for any paid leave that you did provide. It's a pretty good deal. And let's say you haven't racked up enough of a payroll tax bill to be able to utilize a credit, the IRS will actually give you money. They will pay you back for the paid sick leave that you paid out. So to keep this bad situation happening from happening to you, you can still offer paid sick leave, but you are under no obligation to do so. And there's also no financial support for you to do that now as of March 31. But that isn't to say that now, what you should know is that paid sick leave is still good risk management. There's still a lot to be said for paid sick leave. It can help you manage risk in 2 ways. Number one, when sick people stay home, the rest of your employees don't also get sick. That's good. And we'll get more into that in my next bad situation. That's going to help you if your whole workforce doesn't get sick. It's also good risk management because it helps to create employees that are happier, and disgruntled employees tend to go looking for reasons that they can sue you. And that, of course, is not something that you want. So it might not be a like technical legal strategy to offer paid sick leave, but it still can work out for you in the end by managing risks in other ways.
Rachel, Anna did have a question about paid sick leave there. Did you see that, or should I read it to you?
Let me open that up and move it out of my box here so I can see that.
She just says, do you have any advice about structuring paid sick leave? So
Sure.
perhaps.
Yeah, great question. And also thank you, Anna, for putting that in the chat box, and everybody else, please, your questions, I want to answer them. Love questions, put them in the chat box. You can also, if you don't want to ask it and have everybody see your name, you can click on the arrow where it says everyone by default, and you can send it to myself or to Annalisa privately, and we can answer them that way too. So definitely get those questions in there. Do I have any advice as to structuring paid sick leave? No, not from a legal perspective. You can structure paid sick leave the way you want to structure it. Absent a union bargaining agreement or something like that, you've got a lot of latitude. You always want to watch out for the potential for discrimination. You don't want to discriminate against anybody. And the best way to make sure that you're not discriminating is to always treat like people the same. So I don't have any advice for how you should technically structure the paid sick leave. I would just say, make sure it's structured the same way for people who are similarly situated. Like all of your hourly employees get this type of paid sick leave. All of your salaried get this type. Or maybe everybody's hourly, but you have management or not management or part-time or full-time. Just make sure that everybody's who is similarly situated is being treated the same. Also, make sure that whatever you do come up with, that it is thorough and it is objective in its criteria. So maybe you would say, you can take sick leave if you have, you get paid sick leave if you have an infectious disease. Well, what's an infectious disease? Then you should define infectious disease because maybe what you mean is coughing and sneezing. so that you don't infect the people nearby. But what if I have like a topically infectious thing going on, like kids in pink eye and stuff like that? Is that what you mean? Is that an infectious disease per what you were thinking? So it can be a lot harder than it seems to write paid sick leave if you are trying to be really detailed about it, if you're trying to have a lot of control over when people do or do not take sick leave. The easier way to go is to say, look, everybody gets 5 personal days. Everybody gets 5 personal days. I don't care what you got going on. You don't have to tell me. You don't have to like submit a doctor's note. Just tell me that morning when you're taking, and that's why people call it personal days, is because they don't care why you're doing it or what you're doing. Just take a day off. So that's the easiest way to go, because it's like really easy to apply to everybody, and it doesn't expose you to any of these problems with how are you defining things and how are you making sure it's equally applied. Okay. So other bad situations. There's an outbreak of COVID with your employees. Could you be liable for that? Well, this is, of course, this is potentially a legal problem, but of course, it's a huge practical problem too. If all of your employees are out for a week or two, like that's pretty awful. Work is going to get pretty far behind. Replacement workers are not easy to come by. Your work could be very time sensitive. You've got that narrow window when the ground is dry enough and your seedlings are big enough and they got to get in the ground. So you don't want that to happen anyways. But also, you could potentially be legally liable for it. Potentially. If you did not adhere to common practice in terms of providing access to sanitation and social distancing during work and in relation to employee provided housing, then you can be sued and potentially responsible for that outbreak. So the resolution for this, of course, is to follow issued standards. Now, you want to follow standards because it limits your risk of negligence-based liability. So what would happen is sick employee A files a lawsuit against you saying Farmer Jill caused me to get COVID because she negligently did not provide any hand sanitizer gel. She made me work too close to someone on the planting machine. She didn't make PPE available, and the gal sitting next to me didn't have a face mask that day, and there was no substitute for her. There was no replacement face mask. She might have a case that you negligently caused her to catch COVID from her colleague. So don't do that. Consult what the standards are and then follow them. The best place to start is the CDC's checklist for agricultural risk assessment and control planning, if you're looking for what's going to have the broadest legal applicability. Now, I'm not saying that that is the easiest document to understand or that it is geared for a small farm. My job right here, right now, is just to tell you what's going to have the strongest legal credibility, and it's going to be something from the CDC. So check that, but also you can compare that to things that are far more approachable in terms of recommendations for agricultural risk management for the spread of COVID. Use those other documents that you can find, out there through state departments of agriculture, extension offices, and those sorts of things. Those things are good too, but look at them all together to get a good sense of where you need to be. It is all quite common sense. Good things that you can do are screening for illness, like taking temperatures when people show up, using cohorts, like always having the same group of 3 people do tasks together. Have social distancing, make PPE available, encourage and incentivize, if not outright require, its use, and of course, hand washing and sanitation. If you do those things, the chance of you getting a lawsuit against you for negligently causing COVID to be spread in your workforce is very, very low. Anything can always still happen, but it's probably not going to get very far. Your other resolution to this is to offer workers' compensation. So workers' comp gives your employees a source of funds if they get sick in the course of work. That would include catching COVID while at work. The thing with workers' comp is that any individual who gets sick for any reason, not just COVID, and it's related to the job, or gets injured on the job as a result of the job, they can't sue you. They can't sue you under negligence-based claims saying that you caused this to happen. And in your non-COVID context, that applies for everything else too. If workers' comp is available to an individual who has been injured in the course of employment, they can't sue you and make claims like, I wasn't trained properly to use this equipment. This equipment was broken. My colleague wasn't trained properly. And or the boss never should have hired that colleague. They were not qualified to do this job. And those are all the reasons why I was injured. Workers' comp was created to protect businesses, not to protect employees. And this is why. Because it prohibits workers from suing their employers for bad working conditions. And that's not to say businesses wanted bad working conditions. That's what OSHA is for. OSHA regulates safe working conditions. And so taken as a whole, the system says, look, if we're complying with OSHA, then I'm sorry, you can't sue us. But we have this other system for you to be made whole. You get your medical bills paid for, you get compensation for lost income, you get mileage to doctor visits and things like that. So it's supposed to be, a nice contained system for taking care of workers and protecting businesses from unpredictable negligence-based lawsuits that can get you penalties in the millions of dollars. Okay. I don't see any more questions. I'll keep going. Oh, I see one. The PPP program was just extended until May 31. Does this have any implications for access to funds for sick leave in 2021? It does not directly. Now, what participation in the PPP program is going to do is get you funds to pay your payroll. You can yourself have a sick leave program, and you can pay someone sick leave if they're out sick, and you can still use the PPP funds for those payroll costs. So sort of in an indirect way, you can use the PPP funds to pay for payroll that was for sick leave. But it doesn't have like any sort of bump up, or there's no mandatory obligations to offer paid sick leave or anything like that. Okay. So bad situation number 4. An employee comes to you and requests overtime pay, and or they file for unemployment insurance. And now the unemployment insurance division is poking around saying, Division of Economic Security or whatever have you, looking at what you're doing, and you're thinking, but wait, no. I'm a farm. I don't have to pay overtime. I'm a farm. I don't have to pay into unemployment insurance. That might be true, but bear in mind that employees who do at least 1 hour of non-agricultural labor in the week are entitled to overtime and unemployment benefits, as well as the minimum wage, should you not already be paying that. So this comes up because a lot of farms changed their marketing strategies during COVID. Maybe before they were doing wholesale to restaurants. Maybe they were growing flowers for weddings. Now maybe they start a CSA, or they're doing some U-Pick, because U-Pick has been really popular, outdoor, socially distanced. Okay, now we're talking about the possibility for non-agricultural labor. What is ag and non-ag labor? Agritourism is a really dicey territory. A lot of that could be considered non-agricultural labor. especially if you're doing anything that involves like food service. If you have food trucks out to the farm and you have staff that are, helping people find a picnic spot or get to the picnic table, or, you know, um, setting up porta potties and those sorts of things for an agritourism event. Assume that that is not agricultural labor. If folks are packing CSA boxes, especially if those CSA boxes involve product that is not produced on your farm, like they're putting in a loaf of bread or a thing of cheese from some other person's farm, the safe thing is to assume that it is not agricultural labor. It's even things like, now this doesn't apply now, but just to show you what this really means in a big picture, it is driving to restaurants, dropping off product for chefs to sample, making marketing calls. Hey, buyer ABC, do you want to buy our arugula this week? That is also potentially non-agricultural labor. So as soon as an employee does those things for at least 1 hour, you need to assume that you have lost your exemption from overtime and unemployment benefits for that week. You need to pay time and a half for all hours worked over 40. And your best bet is to start paying into the unemployment system. That one's a little harder because you can't go back and forth in terms of paying into unemployment. You can go back and forth in terms of your overtime obligations, but you better just jump in the pool when it comes to unemployment and start paying into the state and federal systems. Yeah, great question. I see that one. So yes, state and federal. So yeah, this was my slide on that. The exact definition of agricultural versus non-agricultural labor is complicated, and it continues in a trickle to weave its way through the court system, federal and state. I don't see a lot of state-specific activity here, but absolutely southern states, California, Washington's constantly getting litigated, and all of those are influential to Minnesota. So are definitely not ag list: classes, education, food service, staffing a retail shop. Potentially non-ag is home delivery, packing product not grown on the farm, cultivating restaurant buyers, and working exclusively in the pack shed on packing tasks. So what do you do about this? Well, when in doubt, pay at least the minimum wage, the Minnesota minimum wage, pay overtime, and pay into the UI system. If that's not tenable for you, if that's just not going to work for the system that you've got going, you have some other options. You can separate the positions to create entirely ag labor jobs and then entirely non-ag labor. Although it's much less important that that be entirely not ag labor, it just has to be you're following the non-ag rules, minimum wage, overtime, UI. So you have just your field work people, and then you have your people who do the delivery and the marketing and the packing. The other thing you can do, of course, is assign the non-ag tasks to immediate family to whom you generally do not owe the minimum wage, overtime, or UI benefits anyways. So something to consider. I see we've got a question. So my understanding is that I'm exempt from paying into federal unemployment. But if I have someone delivering for me, then you're saying I should be paying into federal unemployment insurance. I am saying that is an area of ambiguity, and if you want to play it safe, you're correct. Then pay into federal and state unemployment. Correct. Now, whether if a claim is made, if that person files a claim for unemployment, or if the state or federal government comes after you and says you should have been paying into unemployment, now you could get an attorney and go to court and say, look, I mean, they were delivering my product that only I grew, and they were delivering it to a wholesale buyer. You're going to have a stronger case. The element of it was all my product and it was delivered to a wholesale buyer. But the more we get into a direct to consumer context, and the more that looks like retail, the more we're shifting to non-agricultural. There is no clear and bright line here. this is difficult, and I apologize for that I can't make that part of it easier. The safe thing to do is, if there is ambiguity, to pay into the UI system, or to create these separate positions and give those tasks, those non-ag tasks, to immediate family or people to whom you otherwise do not have to pay, don't owe these obligations. So this can feel really overwhelming. And I want to remind you that risk has two components. How likely is this horrible thing to occur? Like you getting sued for not paying UI benefits, UI tax. How likely is that to happen? Number two, how bad will it be if it does happen? And that's what you got to consider when you're thinking about all these bad things that can happen, because otherwise nobody's ever going to sleep again. Farmers are good risk managers. You can do it. You can manage that risk. Think about it in these two different ways. How likely is this bad thing to occur? How bad is it going to be if it does occur? So if you don't pay into UI benefits, what's that going to look like? It might look at this like the state or federal government getting involved, and nobody really wants that. Are they just going to expect you to pay back taxes? Is there going to be a penalty? I can tell you the number one thing that will be really bad for you if it does occur is if somebody gets injured and you don't have any coverage for that. You don't have workers' comp, you don't have liability insurance. That's when it's going to be really bad, because we're talking medical bills that could be hundreds of thousands of dollars, depending on what happens to this individual. So for my money, I always focus on injuries first. How can we minimize the risk of injury, and how can we make sure that we're covered if it does happen? Taxes and penalties. The penalties for not having workers' comp are huge when you are obligated to carry it. So know those and follow those, because that can be, you pay all the medical bills with, your farm's cash, or you sell all your assets to pay for it. And then there's also a penalty on top of that. So those are my tales of woe, but that's how I try to get you to still sleep at night. Think about how you can manage that in a rational, prioritized kind of manner. So, and of course, tackle the things that you can tackle, like, let's go back to our easy ones, the vaccines. Make them optional, help people get to a vaccine. Don't worry about the paid time off situation. Offer the social distancing, the sanitation, the PPE, and then you're just down to, do you owe overtime or unemployment insurance? And know that you're not alone. There's a lot of farmers that struggle with this, and struggle with these exceptions being very limited, but not realizing that they're limited. That's part of why Farm Commons exists, to help people understand what the limits are of these exceptions. So we're going for 45 minutes of programming and saving some 15 minutes at the end. So we got a lot of time. Do we have any more questions?
There was a question that came in as part of the excuse me, registration process, Rachel. Somebody who runs a UPIC said, do we have to have some sort of washing station for customers and employees to use hand washing, I assume, before entering the field to pick blueberries?
Right. Great question. Well, there is no rule that says you have to offer sanitation to your UPIC customers. But the risk of not doing that is that someone would say, look, I got COVID from a fellow customer, or I got COVID from your employee because you didn't provide me with sanitation. So it is possible that that could happen. However, it is extremely unlikely that it could happen, for the main reason that it would be very difficult for that person to prove that they got COVID on your farm from a customer or an employee. Like, how many other places did they go that day? Where had their children been in the last, 5 hours? They're going to have a really hard time establishing the evidence that that happened. They could make an attempt, though. They could file the lawsuit and try to get that evidence if they were really upset with you. So that means it's, it's still a good idea because you don't want to make those people mad, and you don't want to even have the possibility that they would file that lawsuit just to see if they could make a go of it. So, so the technical answer is no, you're not obligated, but it's still a really good idea. Make your life easier.
Roger asked, possibly as a follow-up to that, does the size of the farm make any difference in that answer?
For that question, no, the size of the farm wouldn't make a difference. Somebody could still be anxious that they got COVID from you and the lack of hand sanitizer, and they would not have an easier time or harder time succeed. They're already going to have a really hard time succeeding on that claim, no matter the size of the farm. Yeah. So someone says, if a farmer really wanted to require vaccinations, could they simply make a statement like all employees will be required to obtain a COVID-19 vaccine unless they have a religious or medical reason to abstain, and then not ask for proof or details if someone does abstain? Yes, absolutely. You can make a statement like that, and then you can just leave it alone. You're covering your bases by saying that you can get an exception for religious or medical reasons, and that is important. Um, you do have to be verbal or verbal or in writing, about that exception, because if you put out a job announcement, for example, and you said all employees will be required to obtain a vaccine, full stop, you put a period there, that's a problem, because what you're saying is anybody with a religious exception or a religious objection or a medical reason don't even apply. And that's bad, because that is discrimination in hiring, to tell a certain type of person not to apply for your job. So as long as you are really doing it this way, it's totally fine to just like let that lie. Don't ask for proof, no details. Yeah. I see Roger says he was thinking of overtime and unemployment. When we are asking the question of agricultural versus non-agricultural labor, and that non-ag labor needs overtime and unemployment insurance, it doesn't matter the size of the farm, because what's happening is farm rules don't apply. Once you assign non-agricultural labor, you're following normal rules. And for normal rules, you pay into unemployment and you provide overtime for all hours worked over 40. That's federal law, so it applies to everybody. Another question, can workers' compensation be used if someone gets COVID, even though they don't contract COVID from the workplace? No, workers' comp is only available for workplace-related injuries. And so if they contracted COVID at home, no, you can't use workers' comp. That, of course, begs the question, how do we know where they got it? And that's going to get sticky. And I am sure that there are many, many situations where people are going back and forth about that right now, where the employee is saying, I got this at work. And the workers' comp company is saying, no, you didn't. You got that from going to the grocery store. And the employee is going to have to present some evidence, but look, 8 other people got sick on exactly the same day. And we know that this person was like patient 0 who brought it into the workplace. And the workers' comp company is going to have to deal with that if there is evidence that this was work related. Okay. Someone says, can you ask to see proof that an employee has gotten a vaccine if you decide to require them? So I have not read the full details on that. I would say that if you are going to do that, you need to speak with an attorney who can take a look at, and you can Google it too. There is a lot more out there on how you can request proof, but you absolutely have to do it in the right way. What you don't want is someone submitting proof that contains more information than you really should have about their medical situation. You don't want that. You don't want to know that medical information, and you don't want to store that medical information. Both of those things can end up being legal problems for you. The knowing, because are you discriminating against them if you then found out that they had diabetes or something like that in the course of that? You don't want to store that medical information improperly and then create the risk that other employees will find it or someone else. So if you're going to collect that, you need to do some research to make sure that you're doing it in the right way. You're managing your own exposure to risk for keeping, knowing, and storing that information. If that's something you already do in the course of your work and you're accustomed to storing medical information, you might be in a better situation to do it. A question: if you require masks on a U-Pick farm, can you turn anyone away who doesn't wear one? For the most part, if you run, an independent, privately owned business, you are allowed to refuse service to anyone for any legal reason, and any legal reason is a reason that is not discriminatory. So you can turn folks away for not wearing a mask because that is not a discriminatory reason. Watch out though if and I know of course you're not going to do this, but this is just an example. No, we prohibit entry to anyone who's not wearing a mask and all pregnant people. You can't, because you can't say no pregnant people because only women can get pregnant, and so you're discriminating against women. So be careful, but for the most part, nobody without a mask is fine.
If you had a moment, Rachel, could you talk a little bit about some of the COVID relief programs, maybe like the Paycheck Protection Program or other those kind of programs updates for this year? I know that's a big ball of wax.
Right. Right. It's a big ball of rules that are constantly changing, and I'm not always sure that I'm up on the latest. PPP is still active, so if you have not gotten any federal funds and you are suffering or did suffer because of COVID, take a look at that. It's quite amenable, and even if you can't show losses and you haven't had COVID and you haven't had any PPP funds yet, it's possible that you can still get about a quarter's worth of payroll. I mean, a calendar quarter's worth of your payroll in a grant. So take a look at that. CFAP, Coronavirus Food Assistance Program, had some granting money in it. For the most part, those deadlines came and went in December, but there have been several more runs of the program for different purposes. It opened up to like contract poultry producers and on different timelines and growers of certain types of commodities. And it's open again for socially disadvantaged business owners who did not receive very much money the first time around. So if you haven't had any PPP or CFAP money yet, and you think you might be eligible, it's absolutely worth looking into. The best place to go, head to Farmers Legal Action Group or flaginc.com, I think they are, .org. They produce a terrific guide and are keeping up on all the latest in COVID relief funds. We did a lot of work early on, but then we sort of trailed off as the bulk of people had been taken care of. Oh, our PPP and CFAP counted as income for tax purposes. I can't comment on that. You definitely have to work with your accountant to get the latest on that. Accountant or tax preparer. I had an answer at one point, but we're always worried about tax stuff because those things are changing a lot. I think we packed a lot into an hour, but we still got a little bit of time left if there's anything lingering.
And then we did record this, so it'll be available for anybody that wants to watch certain parts of it again, or maybe needs to show parts of it to other people that they work with.
Rachel, I had a follow-up to Roger's question about the ability to enforce mask wearing among customers, would you say that the answer would be the same if he was talking about employees?
Yes. You can require your employees to wear masks. You need to pay attention to those exceptions for, religious or medical reasons, because you don't want to discriminate on those grounds. And that can, it's a little bit easier when it's a customer. It's like, well, they can go buy their product elsewhere. It's not, there's not as much writing on your policies in that way. But when it's someone needs to earn their living, and they say, well, but I have a medical condition, then you have a lot more motivation to say, what medical condition, and to try to develop that out a little bit further. And that, again, is probably when you need to go to an attorney to try to get some more support in terms of getting into the specifics of their medical condition and not exposing yourself to too much information, and establishing if it is legitimate enough of a medical condition. So I guess what I'm saying is, if your employee resists, you're in a more hazardous situation to just be like, then go home, I'm firing you, or go home without pay. Like that means a lot. And so we're going to want to do that with more support and more awareness of the legal mechanics around that. So I hate to say it, but yes, your best bet is to let them continue to work the day, because they need that money, and then talk to an attorney as soon as you can and get some support.